a seat. Thanks for coming. My name is Pete McGinley. I'm the co-president of the Georgetown chapter of the Federalist Society, along with my colleague Ryan McNulty. And today we are excited to kick off our year with our first event, The Future of Free Speech in America. All of the Federalist Society events here at Georgetown are designed to draw attention to the three core principles of the Federalist Society. The first is that the state exists to preserve freedom. The second is that the separation of governmental powers is central to our Constitution. And the third is that it is emphatically the duty of the judiciary to say what the law is and not what the law should be. Today we are lucky to have three esteemed speakers with us today. First, all the way on the end, is Professor Mike Seidman. He received his bachelor's degree from the University of Chicago and his JD from Harvard. After graduating from Harvard, Professor Seidman clerked for Judge J. Skelly Wright and for Justice Thurgood Marshall. Following these clerkships, he joined the D.C. Public Defenders, and he now serves as the Carmack Waterhouse Professor of Common Law here at Georgetown. Next, right here next to me, we have Professor Josh Blackman.
Hello.
He is from the South Texas College of Law in Houston. Professor Blackman grew up on Staten Island in New York.
Wow, that's what you mentioned?
He attended...
Never had that introduction before. It's good.
Hey, it's important where you come from.
Okay.
He attended the George Mason University School of Law, which is now the Antonin Scalia Law School. His teaching and scholarship focus on constitutional law, the Supreme Court, and the intersection of law and technology. He is the founder of Fantasy SCOTUS, which is the internet's premier and perhaps only Supreme Court fantasy league. He regularly blogs at joshblackman.com. Professor Blackman also produces thoughtful scholarship at a really impressive rate. He will be featured in an upcoming issue of volume 107 of the Georgetown Law Journal, so we're very thankful for that. And we know that our more skittish colleagues at GW Law canceled your event earlier today.
They did. They were about the weather.
And so we're thankful that you still came to be with us today. Finally, last but not least, in the middle we have Professor and Associate Dean John Mikhail. He grew up in Toledo, Ohio, and he graduated from Amherst College with a degree in political science. He then received his PhD in philosophy from Cornell and his JD from Stanford. It's certainly worth noting that Associate Dean Mikhail completed his dissertation while a first-year law student at Stanford, so all you 1Ls, you can do this. He is now a research professor, a professor of law, and an associate dean here at Georgetown. His research and teaching are focused on con law, criminal law, torts, international law, jurisprudence, moral and legal philosophy, legal history, and cognitive science. He is currently teaching Con Law 1 and will be teaching an advanced con law seminar in the spring with Dean Trainer. So please join me in welcoming our esteemed guests today. Professor Seidman, you can start.
So I'm playing the role of moderator here, but our first order of business is for me to butt out and let you hear from our two distinguished debaters here. So Mike, why don't you begin?
Well, thank you all for coming, and thanks to the Federalist Society for organizing this and inviting me. My own thoughts about this topic are ambivalent and evolving. So I want to start by asking your forgiveness if my comments are more diffuse and confusing than usual, and that would really be saying something. I think it might be helpful to start by making a distinction between free speech law on the one hand and a free speech sensibility on the other. Free speech law, at least as it stands today, is, I think, mostly a force for evil. It is dominated by discussion of things like the exact meaning of content neutrality, the difference between a limited public forum and a designated public forum, or the original meaning of free speech as it applies to things that the framers didn't know about and certainly didn't think about. As interesting as those discussions are for law professors, and as much as I enjoy torturing my students about them on final exams, none of them has anything meaningful to say about the role that speech should actually play in a modern, well-functioning republic. They are beside the point. They are a way of changing the subject from what we should be talking about to things that really don't matter at all. Worse yet, free speech law rests on assumptions that I think should be anathema to all of us and that most of us reject in other contexts. Assumptions like the assumption that people are free, necessarily free when the government fails to act. That, in other words, when Congress makes no laws, that's what makes us free. And that government regulation is always a force for evil. It should come as no surprise, then, that the modern court has seized on the First Amendment to produce what some commentators have called the new Lochner. Among the court's victims, proponents of campaign finance reform, opponents of cigarette addiction, the LGBTQ community, labor unions, animal rights advocates, environmentalists, targets of hate speech, and abortion providers. While striking down laws that protect all of those groups, the court upheld a statute that cut off all funding to colleges and universities that refused to allow the military to recruit on campus, and it upheld a statute that criminalized purely political speech that constituted neither an incitement nor a clear and present danger when the speech, quote, materially supported a group that the State Department labeled as a foreign terrorist organization. So that's free speech law. A free speech sensibility is quite different. By that term, what I mean is an openness to new ideas, a spirit, as Leonard Hand said, that is not too sure that it is right, a curiosity about how someone you disagree with could have the views that she does, a willingness to engage in open-ended dialogue, a readiness to listen and to learn. In other words, the kind of virtues that the Federalist Society promotes in events like this one. That free speech sensibility, by the way, is especially important in a university setting. It would be very strange if students came into universities already knowing everything that they have to learn there. And one of the things that they need to learn is how to have a free speech sensibility. And university faculties and administrators need to think hard about how to instill that sensibility. By the way, at least in the case of law schools, a first step in that direction might be to disabuse them of the religious aura that often surrounds free speech law, to teach them, in other words, to be open, curious, and not so sure that they are right about the value of free speech law itself. In any event, to the extent that left-leaning law students fail to exhibit a free speech sensibility, I think that we have a duty to educate them. And to the extent that universities fail to instill that sensibility, we should condemn them. I do want to qualify that point in three separate ways. First, I have to say I don't envy university administrators who actually have to write the rules that accomplish that objective. There are fine lines that need to be drawn and reasonable disagreement about where the lines are. So I don't think that students have a right not to confront ideas that they dislike or that make them uncomfortable. But I do think students have a right not to have swastikas and nooses put in the corridor of the dorm room where they live. Speakers have a right to speak without being shouted down, but they have no right to speak without having to answer questions, some of which might be very hostile or even inflammatory. Getting the right balance is a difficult business and ought to be open to debate. Second, although the most publicized complaints about speech on campus have been about left-wing snowflakes, there's more than enough blame here to go around. So, for example, in recent years, academics have been denied tenure for expressing anti-Israeli or pro-Palestinian views. And worse than that, it gets worse than that. Last week, the Department of Education sent out a letter saying that it would violate Title VI for an educational institution to tolerate anti-Semitism, which it defined as, among other things, denying the Jewish people their right to self-determination, e.g., by claiming that the existence of the State of Israel is a racist endeavor, and applying double standards by requiring of it, that is the State of Israel, a behavior not expected or demanded by other democratic nations. Apparently, it's perfectly lawful to deny that the Palestinian people have a right of self-determination. I have to say that this hits me where I live, because it is actually my belief that the State of Israel is a racist endeavor, and precisely because I'm a proud Jew, and Israel purports to speak for the Jewish people, I hold Israel to standards higher than I would other nations. I could easily imagine myself writing a law review article saying those things. In fact, I just said them. The letter might be taken to mean that if the Georgetown Law School permits the Law Journal to publish such an article or sponsors this event, it risks having its funding cut off. That brings me to my last point. I do think that conservatives are sometimes a little confused about free speech on campus. As an illustration, consider a particularly ugly incident involving Charles Murray, who was effectively shouted down at Middlebury College. To be clear, I don't for a moment condone what happened at Middlebury, but I am in some ways a little surprised that conservatives have attacked it. Remember now, the conservative position is that when government makes no laws, speech is free, and that it is government that is a threat to liberty. So their position, for example, is that if one student silences another with hate speech, that's not a constitutional violation because it's just private conduct, and indeed, the hate speaker may well be asserting her First Amendment rights. But if the government punishes hate speech, that's a constitutional violation because what the Constitution prohibits is government action. And why is that? Because government non-action is what makes us free. Well, if you hold that general view, there is a problem because Middlebury is a private college. It follows, I think, that it has a First Amendment, from the conservative point of view, that it has a free speech right to use its property, that is to say the college, in any way it wants to. If you don't like Middlebury's attitudes toward campus speech, then don't give it money, or if you're a student, go to some different college. When conservatives instead complain that Middlebury is violating free speech rights, they are embracing a view that progressives have long insisted on, that actually there is a problem with private power as well as with public power, and that people are not necessarily free when the government fails to act, and that private power can also invade freedom, like the freedom of Charles Murray. If conservatives are, in fact, coming around to that point of view, I'm more than happy to welcome converts.
Thank you. Thank you, Georgetown, for having me. I love coming with my friends at the Georgetown Law Center. Where's Pete? We got some show and tell. Oh, thank you. Okay, you got it. So our topic today is the future of free speech in America. Generally, when I talk about legal issues, I can analyze them dispassionately as a professor. But this is not one of those issues. Last spring, I was invited to speak at the CUNY Law School in Queens, New York, and the topic was free speech in America. The students protested and heckled me. I want to play, the entire video is about an hour and change, but I want to play, maybe a short clip. I'll just tell you when to stop it. But just pay attention. There's a lot of noise going on, but I think you should be able to hear it. So just roll it, please.
But I want to make a few points. For example,
Okay, just pause it for a second.
you wrote
Yeah.
that I supported.
Okay, so here's what's going on. Just now you have the setup. A couple of days before the event, the students did some opposition research on me, which is always fun, and they had these pamphlets of all these various positions I've taken which demonstrate that I'm a white supremacist oppressor. These are the things that Blackman is an oppressor, he's a white supremacist, go right down the list, he hates everyone. And then one of their allegations concerned the travel ban. Another allegation concerned the DACA, the Deferred Action Policy. Now, my position is somewhat unique. I think DACA is an excellent policy, but I think it's not legal as an executive action. It should be passed by Congress. So I'm trying to engage these students who are calling me a white supremacist oppressor. All right, roll it.
The President's decision to rescind DACA. Now, let me tell you something. I actually support the DREAM Act. This might surprise you. I actually think the DREAM Act is a good piece of legislation. And
Okay, pause for a second.
remember,
Okay.
oh, let me speak, please.
So gaslighting, you know what that term means? Gaslighting is a term, it comes from a book, I can't remember the book's name, where you try, what's it from? Gaslight, that's easy enough. Where you try to confuse people by giving them a false sense of reality, fake news, if you will. So they think I'm trying to spin them. All right, just roll, and I'll probably tell you pausing. Sorry, I've commandeered him for the.
And were a member of Congress, I would vote for the DREAM Act. My position is that the policy itself was not consistent with the rule of law, which teaches a lesson, right? The lesson is this: you can support something as a matter of policy, but then find that the law doesn't permit it. And then the answer is to change the law.
Fuck the law.
Fight the law, right? That's a very good thing. You're in law school, right? And it's bizarre thing to say fuck the law when you're in law school.
Okay, pause. Okay, that's enough.
You
That's
chose
enough.
Judy, didn't you?
Okay.
Because you knew what would happen.
Okay, that's enough. Okay, you've heard enough. Thankfully, you didn't do that to me, so congratulations. You're better than CUNY in more ways than one. But I want to focus on that premise the rest of my talk. Fuck the law, right? I'm cursing, yes. It's true. Fuck the law. The basis of the fuck the law mantra is not just fuck the law, but fuck our law, which includes, I think, free speech. And I think Professor Seidman articulates an idea far better than what these students articulate. Professor Seidman has a good article. You should read it in the Columbia Law Review. Can free speech be progressive? And he argues in a nutshell that it really can't. That even if, incidentally, the First Amendment protects progressives along the way, the flag burner, or the person who wants to burn his draft card, for example, or the anarchist, right? He calls these crumbs, right? That these are incidental benefits of free speech, but the costs of the First Amendment far outweigh any of these crumbs. So, for example, he cites Citizens United, which was a case about campaign finance. I'm sure you'd had the Janus decision about the labor unions decided this last term, right? He calls the First Amendment possibly the new Lochnerism, right? This idea that unelected judges have the power to weaponize the First Amendment, to use Justice Kagan's expression, to invalidate otherwise democratic laws. So Professor Seidman's far more eloquent than the students at CUNY. He doesn't say fuck the law. He says, forget our law, right? Our law leads to non-egalitarian results, and there's no intrinsic reason for keeping it. Now, he's not proposing that we kill the First Amendment or repeal it. I don't think that's his proposal. But we should recognize that he has a point, and I want to make this clear, right? The First Amendment does impose costs on our society, right? It does perhaps protect things that maybe you may not want to protect. So then maybe we're right. Maybe we should just fuck the law and move on with our lives and stop giving protection to free speech, because that would stop corporations from contributing to campaigns. It would stop states from busting up unions, perhaps. It would give a more progressive result. But I humbly submit that the costs of this proposal are far greater than perhaps Mr. Seidman or others will concede. Specifically, when I look at those students at CUNY, it pains me. Why does it pain me? This is a looking glass to what the future of our legal profession might look like. And we live in a society today where the court is fairly consistent that free speech is a value worth protecting. But if you have law students raised and inculcated in this sort of environment, they lack a basic appreciation of why historically free speech ought to be protected. And they don't understand that what this is basically asking for is control. Control over who can say what. And my fear is we don't need to overturn the First Amendment to get the CUNY kids in charge. We have all the pieces in place. right? We have doctrine about incitement, for example. We have doctrine about harassment, which is a fairly nebulous term. We have doctrine about workplace aggression. And there are lots of doctrines in place that I think could very easily swing to open the door to regulating aspects of speech. And this, frankly, hits very close to home. Now, I'm not some sort of oligarchy. I'm not a corporation donating millions of money to, I'm a law professor. We don't make a lot of money. My concern is specifically conservative speech, right? There is a difference between Milo Yiannopoulos, Richard Spencer, and Richard Epstein, okay? There is a huge gap between people who I think do espouse awful, awful views and people who take a classical liberal view of the Constitution. Myself will be included in that perspective. And the inability of these students to distinguish between downright racists and hateful people who say really bad things and someone who wants to talk about, I don't know, the Commerce Clause, this thing boring, is why I'm so skeptical of Professor Seidman's theory. If students can't grasp why not all degrees of speech are of this odious nature, then I am not comfortable giving the government the power to censor, right? If we don't have perhaps the sensibilities, which I like his word, if we as a society lack those sensibilities, then I want to keep this speech out of the political process because I don't trust the CUNY kids, if they're one day the district attorney for Manhattan, to prosecute me for incitement because I argue that the DREAM Act is unlawful or the DACA executive action is unlawful. I don't trust them because they lack those sensibilities, okay? But I want to take a step back and look at this more broadly. There is a very lively debate within the civil liberties community. And look no further than the American Civil Liberties Union. And the head is a school professor. What's his name?
David Cole.
David Cole. I want to say David Barron, but that's wrong, David. David Cole, who, for example, is a professor at this college, is the head of the ACLU. And I think he has a fairly robust debate within his own organization, right? A generation ago, there was a very famous incident in Skokie, Illinois. We all know about this incident, where the skinheads wanted to march down the streets of Skokie, which was a predominantly Jewish neighborhood. And their purpose was just to basically piss off the residents, right? Make them angry, share their ideology, intimidate them. There was no doubt what their intent was. And the ACLU defended the Nazi protesters, the skinheads. They defended them. And even at the time in the 70s, this resulted in a very vigorous debate among civil libertarians, right? Should we protect the speech of these awful people? And the ACLU backed them. And that had something of a status quo for years. But in recent years, there's been a shift. And I don't know if it's actually a shift in policy or a shift in perception, that many on the left in the civil liberties community are perhaps taking a second look at this, right? You look at what happened in Charlottesville, right? Should the ACLU defend the people who want to get a parade permit in Charlottesville? I think they did help them obtain the permit. I don't think they helped them afterwards, but they helped those people get their permit. And will we get to a point where the ACLU will say, you know what, for certain speakers, they may not be entitled to the same level of assistance from us? Now, that's not that they should be protected, but they shouldn't get the same level of protection. Well, maybe they have guns, and guns are bad, so maybe we can draw a line at protesters with guns. But what if they are marching without guns, right? This window into the ACLU, I think, represents a broader creep within our society. A creep, indeed, of where we're headed. And if we get to the point where Professor Seidman's theory, I think, takes predominance, and again, I don't think he's nuts. I mean, you might read his paper and think he's crazy. I think he's more prescient than descriptive. I think he's describing a state that very likely will exist in all of our lifetimes. So we need to take this seriously now. Okay. Now I'm going to close on a happy note where we agree. I think we agree on this emphatically. Colleges, both public and private, have an obligation to instruct their students, to teach them about how to have sensibilities about free speech. What happened to me at CUNY, and this went on for a while, should not happen to any speaker, right? It shouldn't happen to anyone. If you have a question, you ask it after the fact. You don't try and stop them from speaking. You don't send inches over their shoulder. The administration at CUNY, frankly, did very little. These people were standing inches away from me. I wasn't threatened, but these things can turn very quickly. And if one of them tried to attack me, I would have been outnumbered greatly. I'm just one person, even though I'm from Staten Island. I don't think I could defend myself against an entire army of protesters. Third, there was no discipline handed down to these students. Absolutely nothing happened to them. Nothing at all. Nothing. Nothing happened to these students. Everything went like normal. I tried to contact the dean. No interest in engaging this issue. So what happened at CUNY is the mistake, and we should use this as perhaps a teaching moment of what not to do. But I think Georgetown has a good culture, and I say this with experience. My colleague, Randy Barnett, I wrote a casebook with him, is a professor here. John Mikhail, Seidman, you have a lot of professors who do not agree, but you seem to get along. And notwithstanding any disputes that happen on a day-to-day basis, there's a good blend of faculty who can advise you. So I'm extremely grateful for the opportunity to speak. I'm going to stop now and give my friends some rebuttal time. But I think we have a very good discussion ahead of us. Thank you all so much.
Okay. I've been asked to make a few comments, but I'm going to limit my remarks just to a few minutes because I really want to give Professor Seidman and Blackman a chance to respond to your questions and have a conversation. So really, let me just say at the outset, I don't teach the First Amendment here, so I'm going to approach this a little bit like a naive observer. I'm obviously familiar with it in its broad contours, but I'm not a specialist. So let me use my time to ask some kind of what I think of as commonsensical questions to the two primary speakers here. I agree that Professor Seidman's article coming out in Columbia is terrific. I commend it to all of you. It's called "Can Free Speech Be Progressive?" And my questions for him, I guess, in reading the article, well, here are the main questions I wanted to ask. I see here a general style of argument which essentially looks to the background conditions of law, the political economy within which law operates, and says that's really the big and more important picture. And for the rest of us, for all of us to focus on the operation, the doctrinal operation of the First Amendment and miss what's really going on in terms of the background conditions is to really miss the forest for the trees. And I think Professor Seidman accurately describes the concentrations of power in the 21st century economy, corporate power in particular, media monopolies that own the means of expression and the means of communication as the background conditions in which the First Amendment necessarily operates. And he rightly points out that in that kind of environment, one should not expect necessarily progressive outcomes from the operation of a body of doctrinal law that the courts would administer. And I think that's generally correct. Think a little bit about the way our political system operates. Politics and elections take place on a stage that is owned and operated by major corporations. And in the course of elections, what is actually happening from an economic point of view is the sale of a product to customers. We are all the product. We're the eyeballs that are being sold to the real customers, who are the advertisers that are the major source of revenue for the corporations that run the entire election on this stage. I think all of that is true, and we should think critically about the way the First Amendment, for example, operates in that kind of environment. However, my questions for Professor Seidman are the following. One is, if this is correct, or something like this is correct, and I may have gotten you wrong, the question would be, is this really, in fact, a critique of the dominance of private power in the American economy, corporate power in particular? So to what extent is this about the First Amendment in particular, or something that could be generalized to many other rights that are also taking place on this broader canvas, the political economy of our society, which I think all would concede is dominated by concentrations of power, not the state, but private power, enormous wealth and power in setting the basic background conditions. And so that's just kind of a question. Is this really a critique that has maybe philosophical roots in Marxism or other bodies of law that says law is epiphenomenal? If you want to really understand what's happening, don't look at the epiphenomenal features of the law, but go to the foundational questions like who owns the society, who owns the means of production or communication in this instance. That's general kind of a question for Professor Seidman. I guess another question would be, in the story that he tells in his paper, he didn't give it to you here, of the sort of the history of the First Amendment in the 20th century. I'm genuinely curious whether he thinks there may have been certain wrong turns doctrinal wrong turns, it's a path-dependent process that if they were revisited might in fact give a different picture? Or is there a kind of a necessity to the whole thing that makes that type of analysis implausible? I think he's inclined to say it's not about individual cases coming out the other way. Professor Blackman mentioned the Skokie case. There's a longstanding criticism of that case, which is to say what happened in that case is that a background body of law, namely tort law, the law of intentional infliction of emotional distress, got just simply put to one side in the service of this broader First Amendment vision. But maybe it didn't have to be so. Maybe just if we talk about the new Lochnerization of the First Amendment, we have to remember that Lochner was all about constitutionalizing background private law. Basically, tort, contract, and property law was constitutionalized and used against government action through the Due Process Clause. But something similar could be done in the First Amendment context, and if that were to happen, it would actually possibly call into question decisions like Skokie, because you would actually say tort law should operate here, the law of defamation in New York Times against Sullivan, or the law of intentional infliction of emotional distress. That is the body of law that should in fact push back against the First Amendment, and it's just a different legal analysis, but not something that takes place outside of law. So that is the second question for Professor Seidman. Are there, kind of stepping stones along the way that really matter, or is his view something that doesn't involve particular wrong turns that could be reversed? For Professor Blackman, I just, I guess, have a question about his general First Amendment vision. I think Professor Blackman is an originalist. I think he identifies that way. And we talked about the Commerce Clause and other parts of constitutional law. Generally speaking, he identifies as an originalist, I believe. And I've always been puzzled by how originalism is supposed to apply to the First Amendment in particular. And what I heard you say was very much a 20th century story. You wanted to sign on to the major victories of 20th century First Amendment law, the kind of classic ACLU orthodoxy. But that's a 20th century story. That's not an originalist story. And can decisions like Citizens United or Janus or, there's a lot of canonical First Amendment decisions that I think many skeptics would say have a difficult time being justified on originalist grounds. And I would like to know whether you think even along those terms, and could you give an originalist justification of your preferred First Amendment? And then I guess the last question, I was struck by what Professor Seidman said about this recent Department of Education guideline. I share his intuition that this is a very bad development. It does seem to me to be the kind of weaponization of the First Amendment where you take a contentious political issue like the Palestinian-Israeli conflict, and all of a sudden the force of the government is going to come down on one side of discourse in that area, and in a very pronounced way that I think is very bad for free speech values, broadly speaking. And I was wondering what you thought of that, what you thought of that case, and cases like it where the First Amendment would start playing a particular role in ongoing political controversies that are on campuses and in law schools, and people care a lot about on different sides. It seems like that's a very bad development for the First Amendment, and I just wondered what you thought about that. So I'll stop there.
Me?
Yeah.
Okay, so there's just a lot here, and so I'm going to try to just hit some bullet points very briefly. First, on the Cooney event, I first want to say I admire you for going into a lion's den like that and defending your position. You just showed a few snippets here, so and this was the first I saw of it, so I don't want to get into details about the rights and wrongs of it. It was a little hard to tell from the snippets, but when I said there's a problem about drawing lines, it seems to me this is actually an example of it. It looked to me, at least to some extent, like the students were exercising their free speech rights. They didn't like what you were saying. They had placards there. They were asking questions that they thought would be embarrassing to you. Now, I do think people have a right to speak without being interrupted, and I think that kind of an orderly debate works better, but when feelings are strong, things like that things like that happen. And I do think there's one of the things, I guess, that bothered me about what you said. In the end, it seemed to me that what you were really objecting to was what they said. That is to say that, as you put it, that they can't tell the difference between a classical conservative and somebody who's on the alt-right, and that you don't trust people who say things like that. Well, fair enough, but that's what free speech is about. People say things you disagree with, and when you say you can't trust people like that, I think it sounds to me like what you're saying is you can't trust the outcome of a free exchange of views between people who have different points of view. So it makes me wonder who is on the free speech side here. You said that it's my position, I think you attributed this to me, I'm not going to use your language, to forget the law, another F word. Well, that just aligns the question of what the law is. And so it's worth reminding people what the Supreme Court has said the law is about this. You know, if they were defending what was actually necessary for a free and open exchange of ideas about things that matter, boy, that would be a great thing. What are they defending instead? Well, they're striking down a law that, or suggesting a law might be struck down that regulates exactly how merchants state their prices when you buy things with a credit card. They're saying, they're striking down a law that required clinics not to mislead patients who come in by making clear that they don't provide abortions. Strikingly, a use of the First Amendment to limit the amount of information that's available to people. They're striking down a law that says doctors can't reveal information about the drugs they prescribe to patients. I'm sorry, those are not decisions that establish the kind of political order that a vibrant First Amendment would defend. And if that's what you mean by forgetting that law, yeah, I'm absolutely for forgetting that. Okay, the answer to John's questions really quickly, I think I can actually answer both of them together. The wrong turn is a really fundamental wrong turn. It's central to at least modern constitutional culture, which is an assumption that when the government doesn't act, people are free. And the assumption is just, in many ways, obviously incorrect. So if you think about the 1964 Civil Rights Act, which was government action that controlled private parties, that those private parties were preventing African Americans effectively from taking a vacation in the South because you had to drive 100 miles to find a restroom that would serve you. When the government acted to prohibit that, it didn't make us less free, it made us more free. And the assumption behind the modern conception of most constitutional rights, at least on the conservative side, is that it's just axiomatically true that when the government acts, it makes us freer. Sometimes it does, sometimes it doesn't. Is that a critique of the way we currently conceptualize all rights? Yes, it is, but I do think we have to be particularistic and careful. I wrote an article about the First Amendment. I've written some stuff about the Fourth Amendment. I haven't written about every right that's in the Constitution, and I do think I want to be cautious about overgeneralizing.
Thank you. I'll also try and move as quickly as I can. I encourage you and everyone to watch the full 70-minute video.
It might be.
I think if you'll watch the first 7 or 8 minutes as they're shouting me down as I'm trying to speak, and I couldn't get a sentence out for about 5 minutes. But I want to disentangle 2 points Professor Seidman made. I have no objection to the fact that they're espousing views I find silly. In fact, had they done it at the end of the event in Q&A, I would have taken any questions they have. Indeed, after this clip, I took questions for over an hour. And a lot of these questions are very uncomfortable. In fact, one of the questions was about free speech and originalism, so I'm actually prepped for this question. But the important point to stress is they weren't even willing to hear me out. If you watch the video another minute afterwards, they storm out of the room. Why did they storm out of the room? Because I challenged them and I engaged them, and they couldn't handle the debate. That is what I'm worried about. Jonathan Haidt and Greg Lukianoff have a new book called The Coddling of the American Mind. It came out this week. I encourage you to take a look at it. Agree or not, they make some fair points about the state of college students. Now, not everyone is Milo Yiannopoulos, not everyone's Charles Murray. There's a lot in between. Let me handle John's questions one at a time. I take my vision of the First Amendment from Thomas Jefferson. That's a pretty good place to start. And if you read his opposition to the opposition to the Alien Sedition Act, I think it's a pretty good basis for what the First Amendment's about. Now, I don't think there's been any meaningful effort to ground Citizens United, for example, in originalism. There just hasn't. The Janus decision, I think Eugene Volokh and Will Bode did a pretty, I think, persuasive paper about why requiring people to pay subsidies isn't really speech. I think a lot of aspects of our free speech case law have not been grounded in any sort of original meaning. I'm pretty comfortable with the idea that the government can't pick sides in a debate and censor winners and losers, right? Pick the speech they prefer and then punish seditious speech they had. I'm okay with that as an originalist basis. But a lot of our free speech case law, I think, is not that. I think government can't censor speech on the basis of ideas. But beyond that, I get a little bit fuzzy. Now, the Israel issue, I haven't looked at this very closely, so I have to just give a sort of off-the-cuff response. I speak as perhaps a second or third Jew on this panel. Happy Yom Kippur everyone tomorrow. The relationship between the Jewish people and Israel is fairly unique. And I think that unique aspect makes this a much more difficult question to analyze. Again, Seidman said there are a lot of Jewish people who do not agree with Israeli policies and do not agree with Israeli self-determination. So I think that's worth noting. But to the extent that the government's punishing people who hold certain political ideas, that I am not so crazy about. And in fact, having an over-aggressive Title VI policy by the DOE, I think, is problematic in a lot of regards. So the mere fact that you have, I think, this close connection between a people and their homeland, which I do think exists with respect to the Jewish people in Israel, you do have the risk that this bleeds into a political censor. And that's why I think if you tread very lightly with this Title VI prosecution.
Great.
So
I think we have a chance now to open up for questions from all of you. And I have bad eyesight, but if you want to raise your hand. Yes, Cameron.
Okay, so I guess my biggest issue is that we haven't really demonstrated a pressing threat to most people's actual practice of the First Amendment. So far, it really seems like the people that complain about a bad campus culture or whatever are just academics or authors who are uncomfortable with being challenged in an obnoxious way at their lectures. So for the rest of us who aren't going around the country to speak publicly and getting shouted down, it doesn't seem like the rest of us are threatened.
I can take that question. So the event I had at CUNY was very informative, not only for the people who protest me, people who didn't protest me. If you noticed in the video, the room looked pretty empty, didn't it? There's no one there. The reason why is that people were afraid of entering. Towards the end of the event, after the protesters left, the room filled in. And by the end of the event, there were 50 or 60 people there. And several students came up to me and they said that we were afraid of entering and being seen associated with you. That they were actually afraid that they'd be shamed. And students tell me this. I speak at 100 law schools a year. They say, we are afraid of sometimes raising our voice in certain classes that will be shamed, not by the professors, but by their classmates. This threat, I don't know how pronounced it is. Maybe it exists, maybe it doesn't, but it does exist. And people tell me about this, and the evidence was in CUNY. So yes, rabble-rousers like me, we're at the front end. But there are a lot of people who aren't outspoken about it who do witness it. And I'll give that for whatever it's worth.
So just a brief comment on that. I think Professor Blackman is right about that. I just want to press him again on what I think is an inconsistency here. So what he's talking about is social power that silences people. And he's absolutely right. Social power does sometimes silence people. It silences people not only on the right, also on the left. So hate speech silences people. But you know what else silences people? The New York Times. So the New York Times has a tremendous amount of social power. It is the paper of record in the United States, and it gets to choose what to say and what not to say. And if you're concerned about social power, then I do think that is the entryway into a general deconstruction of standard First Amendment law, including freedom of the press, because the press is privately owned and they're exercising social power. Much more social power, by the way, than some students at CUNY.
Did you have a question?
I was just gonna, it was kind of a commentary, as a Middlebury student, I'm about 3 years out of Middlebury. It was actually a pretty violent protest. I mean, we had one professor, registered Democrat, who was actually scheduled, she was the one who was supposed to interview Charles Murray. She ended up suffering, I believe, a concussion of some kind because protesters snapped her head back. That's unacceptable, I think, for a professor to be suffering that, and to sort of kind of lump that with the CUNY event, which, not to say that those aren't, but I think what can happen with the CUNY event is it can slip into what happened at Middlebury. And that's the risk that I think is worth noting. It's not that, you know, CUNY protesters were standing there with signs and, you know, that's problematic. It's saying that that event that you experienced, like you said, you could have been under threat. You were one person with, you know, surrounded by 20 people. That can very easily slip into something that's violent, and it can have really disastrous consequences. So I think that, you know, saying that this is something that, not to say that we should be regulating it, but I think it's just something we should be consciously aware of, because it can slip into something that's violent. And I don't really have an answer for how to address that, but that was my only comment I want to say in regards to the Middlebury event.
I would have been much less trouble if they weren't standing behind me. If they had been standing in the back room shouting, I think it would have been a lot easier, but that they were a few inches from my shoulder, it could have turned very quickly at any moment. I think that's one possible line you can draw, that the front of the room where people are standing should not be occupied. I don't. So, Seidman, would you agree with that as a general rule?
So, violence is always unacceptable, and what happened in Middlebury was disgraceful. And when you say there's not a solution to the problem, there actually is. The solution is you provide adequate security, and I think in a situation like the one Josh was in, some spatial separation might be appropriate. On the other hand, there is a long and unfortunate tradition in our country of people using the threat of violence to suppress speech where it need not be suppressed. And I'll just give you a specific example from this law school. So when Attorney General Sessions spoke, not only was he asked only questions that were pre-screened, but the people who wanted to protest, the administration took the position that they had to be in a place where Sessions wasn't going to see them. And as far as I could see, there was no reason why the people who were protesting could not have been in a place carefully policed and making sure there wasn't violence, where he could have seen what they had to say.
I have a somewhat of a commentary, somewhat of a question about this specific example and other examples of conservative speech being, use the word that you will, maybe negatively approached on campuses. At what point does this cease to be a constitutional issue and become a political issue? I've heard people say, why don't they just make their argument better to more people? Why not? You know, we have a very conservative president who decides this.
I would disagree with that.
Okay, so we've got other conservative politicians who, despite this supposed animus towards conservatives, manage to win elections, even in areas that might have more Democrats in them. They might do so by being more effective politicians. Is that an answer to that, rather than going back towards these rights arguments?
The marketplace of ideas should prevail, and if conservative ideas can't hold a candle, then they should lose elections. I didn't vote for Trump. I'm not going to vote for him again in 2 years. I think there are lots of reasons why you can choose to vote for this politician or that politician. My objections to a very specific fault line, which is the shouting down exclusion of speakers on public campus. I didn't draw a distinction, but I agree with Mr. Seidman. Private colleges perhaps have an academic responsibility, but they have no. I don't think they have a legal responsibility to maintain the same sort of form that a public college does. But to the extent that people are being uninvited, shouted down, prevented from speaking, not being invited in the I mean, there are cases where schools want to sometimes invite speakers, and the school says you can't have them. It's not an uninvite, so you never know about it. But there are times, I know about these times, where speakers, they can't be invited in the first place. These are the sort of unseen costs. But yeah, if I come here and I say stupid things, people think, wow, Blackman's a moron, then, I failed. But I at least have the opportunity to speak my piece. Yeah.
So I have a question that's a bit of a hypothetical. And thinking about a Richard Spencer type, I think we can all, the panelists have distinguished, and I think most of us in the room can distinguish between a reasonable academic conservative and a Richard Spencer type. Say a Richard Spencer type is invited by a group on campus to a public university to speak in a university auditorium. What should the end of the story be based on your view of free speech? How should the administration respond? How should liberal students on campus respond? Conservative students on campus respond? Because I'm struggling a little bit with the idea that a kind of absolutist free speech point of view would result in him being allowed to speak on campus and then only receive some nice, polite questions afterwards.
So boy, am I going to get in trouble with this answer. I actually think Richard Spencer has some things that are worth listening to. I don't, so just to be clear, I don't agree with him. But the arguments for white nationalism are things that might upset some people who believe in black nationalism, or for that matter, Jewish nationalism. To get back to Israel, what he is proposing for the United States is what exists in Israel. So it is worth listening to that, in part because it forces people to try to formulate answers and explain exactly why the guy is really evil. And just to be clear, I think he is. So what I would do is I would say, yes, he should come, but no, he shouldn't get polite questions. He should get pointed questions. I don't think he should be shouted down. I think there should be a question period. But I think a lot of very complacent people like me and the people in this room might be shaken up a little by what he has to say, and that would be a good thing and not a bad thing.
Well, one thing about Spencer, he's actually not invited. Most colleges let you rent public space. You can rent an activities room. So usually when Spencer comes, he's not invited. He shows up on his own. And I do think that does make a little bit of a difference. But what I would tell people is protest outside. Make it known that you think it's needed. Ask him awful questions, really hard questions, and show the world. If you don't pin him down and all he does is talking to his own followers, it doesn't really help advance the agenda. I think we're largely in agreement on this last one, largely.
So, at the beginning of your opening statement, Professor Blackman, I heard sort of an acknowledgement that the First Amendment in the last 20 or so years has sort of, whether you use the term weaponized or not, it's being applied in contexts that maybe were not. Maybe those contexts were unprecedented. Mm-hmm. So, to me, that says expansion of its use. But then, the concerns I hear you having are more, with these students sort of wanting to limit it. So I guess what I'm asking is, do you not believe that the First Amendment is being weaponized in cases like Citizens United? Do you think it's being correctly applied there? Because it's sort of like there's robust legal protection, but within society it's going off the rails.
Okay.
But as we both know, the legal side, that's where the laws come from. Society just sounds like a grievance with the state of society right now. So am I hearing you correctly, or? Okay,
I'll answer it. So let's talk about Lochner for a minute. Randy couldn't be here. He's at Cato, but I'll invoke Randy's name, talk about Lochner. The reason why the Lochner era was so controversial, I don't think it was nearly as controversial as it should have been, but the reason why Lochner draws such ires is you have a clause in the Constitution. It says that a person cannot be deprived of liberty without due process of law. And this phrase, liberty, is not defined in the Constitution. which gave rise to what we now know as substantive due process. The idea that this word liberty is not merely a procedural right, but gives rise to substantive right, for example, economic liberty, right? So why was a New Deal court so opposed to Lochnerism? Because you were taking a clause of the Constitution, the word liberty, and using it to apply to things that maybe were not understood as liberty. For example, freedom of contract, right? Judges were making stuff up. Now, I don't think it's accurate. I think the Privileges or Immunities Clause of the 14th Amendment did embrace the right of contract, but I'll put that aside for now. The notion of Lochnerizing the First Amendment is a non sequitur because it's enumerated. It's an enumerated right. Go back to Caroline Product's footnote 4. It says if a right is enumerated, it gets heightened scrutiny. Now, I don't think Caroline Product is a correct breakdown, but for those who do, it's right there, right? Now, what does the First Amendment mean? Is it law or not? I don't know. But the word speech is in there. The freedom of speech means something. What does it mean? I think we can do more homework on what it means. I mentioned this earlier. I don't know that Citizens United is correct as an original matter. I don't defend it. I don't particularly care much about that area of law. It's not my research, but it's not been grounded well. I think the Kennedy concurrence had some stuff on history, but it was a little bit fluffy, right? But what I do know is that the framers understood what the idea of a prior restraint was. They understood that very well. That's something that was clearly understood. They understood that the government can't pick sides in debates. They can't pick the Federalist Party over the Republican Party. Right? That they can't do. And if I just take that basic starting point, I think large chunks of our free speech doctrine can be supported and should be supported and serves, I think, positive purposes. So there was a lot in that question to unpack, but I think if you start on the basic point that you have an enumerated right, I am I'm not really troubled by the Lochner allegations.
So just two quick responses. First, yes, the First Amendment uses the word speech. The Due Process Clause uses the words due process. The Due Process Clause is an enumerated right. It enumerates due process as a right. The truth of the matter is both phrases are very open-textured and have to be filled in some way. And this is not a debate about originalism, but I would insist they simply cannot be filled in by asking questions about the original public meaning. To ask those questions is to ask really nonsensical questions like when the framers did the word speech in 1789 mean video games, right? That question is literally incoherent, and I won't try to demonstrate it now, but I think all of free speech cases turn out to be like that, where you're asking a question that even if there was some reason to follow the original public meaning, which I think there's not, it's not something that can coherently be accomplished. So there.
We have time.
One more, please. Question.
Yeah.
Yeah.
This is cheating a little bit from what we've been talking about, sort of broader free speech, First Amendment philosophy, and Josh mentioned the marketplace of ideas, but I guess both your responses to what we threw out, which is that what's happened in the last 10 years has proved that the idea of the marketplace of ideas selecting truth isn't true. I mean, we've got more speech than has ever been, in history. More people have more access to wider forums than ever, and there's also probably more disinformation and people accepting that disinformation. And what is that? I have a whole list of sort of things that are going on these days that I think could be talked about. But just looking at this, what do you sort of see for the future of First Amendment values, philosophy, all that stuff, given this development? We now, for instance, in the 1970s, access to media was the big thing. That was one of the biggest First Amendment issues. It didn't become part of the law, but now there's access to the media, amazingly. But it didn't turn out the way people thought it would. So I guess I'd like to hear both of your perspective. Where do you think this is going to end up, and is this going to have any effect on, free speech philosophy and ultimately law?
Mark, you want to start?
I have no idea where it's going to end up. I think your on target that free speech problems have changed. We have a problem that didn't exist before, I think, about, or did not exist as seriously, in some sense, of too much speech. So things like Twitter and Facebook are just this huge accumulation of kind of random rantings and God knows what. And in a world like that, you need some sorting mechanism. And so I see a couple of problems. One is, again, the sorting mechanisms are in private hands. Think Facebook and Twitter. These people have a tremendous amount of power, and we cannot elect a new head of Facebook. And then the other problem is what they do is the way they sort, because this is what makes money for them, is they channel the speech in a way so that the ideas people already have are reinforced instead of being challenged. And that is part of what, not the whole story, but that's part of what's producing both the fake news and the polarization. So I do think we need to rethink a lot of the theory of the First Amendment, given modern technology.
Michael, would you consider as utilities, right, treating the social media companies as public utilities?
I think there's something to be said for that. I also think there's something to be said for aggressive antitrust enforcement against them. Yeah, I think, yes, is the answer.
So your question, I think we'll end with this one, but your question I think is very insightful, right? As much as I complain about public, governmental controlled speech, Facebook and Twitter have a far greater say what information I see than the U.S. government ever will, and I will concede that. So then the question is, which would I prefer? Having Mark Zuckerberg or @Jack, right, deciding which tweets I see, or having the people down the block have a say, FTC or down that way, decide what I see? I'm still more troubled by the state doing it than private entities. I think Michael is the opposite. He's much more troubled about Mark Zuckerberg or @Jack doing it than the private entity. So I think there's a philosophical debate that we probably will not disagree on, but I think we are agreed that the private restriction of speech is a much bigger deal than perhaps we realize today. Want to end there? Good.
Two quick announcements before we wrap up. The first is if you're not already a member on OrgSync or a member of our mailing list, please feel free to sign up on the sign-up sheets here in the front. The second is please come out next Wednesday at 3:30. We're having an event on marijuana policy with some scholars from George Mason.
Are you serving brownies?
Stay tuned. And Randy Barnett will be moderating. And last thing, please join me in thanking our speakers today.
Thank you. Thank you. Thanks, John. I enjoyed that. Unfortunately, I've got to